unravel and punish an offender when eyewitnesses turn untruthful and do not support the case. They ensure the delivery of justice, notwithstanding the hesitance of individuals to support the cause. Finally, Bharatiya Saksha Adhiniyam. Bharatiya Saksha Adhiniyam modernizes the Evidence Act of 1872 by enlarging the scope and definition of digital evidence. Today, friends, we are in a domain where documents are passed. We would either have oral evidence, and that too through electronic means, or we would have digital records. How many of you have received a letter from your friends? How many of you have written a letter in the last, let's say, 5 years? Most of us exchange our feelings through messages on networking sites or other means. Exchanges are therefore all on digital platforms. The courts of today would be required to look into electronic records in place of documents. And when we require to do that, the Evidence Act needs to be revisited, and that is exactly what Saksha Adhiniyam does. It redefines the primary evidence in electronic records by expanding it and emphasizes on proper custody and preservation of digital records. The scope of primary evidence now includes digital storage, whereas secondary evidence encompasses matters stored in semiconductor memory. Certification requires dual purpose. It is not only the certification of the person in charge with regard to admissibility, but also with regard to its integrity and reliability on the basis of an expert who can match the hash value and state that the material or the digital record produced in court is not a tampered one. These will go a long way to deliver a justice system which is most effective, uses technology, and reaches out to the needs of the people through the best practices available. Now I come to the salient features. As Justice Ashutosh Kumar pointed out, Bharatiya Nyaya Sanghita, or BNS, makes a paramount change in the reformative idea of punishment. Lesser offences are not subjected to, where you do not, let's say a lesser offence where you do not, or you are not in a position to award someone probation. You may, instead of awarding sentence, substantive sentence, go for community service. And what is community service? Community service is court-ordered work that benefits the community and which is not entitled to any remuneration. And this is where, friends, I had spoken of the three reasons for change. One reason I said was a historical reason. Second reason I said was a change of profile of crime. And the third was the change with regard to availability of technology. The fourth reason for changes, and this I would, as I go through the salient changes, indicate, are the judicial pronouncements which have become now a part of statute law. Many of the changes in BNS, BNSS and BSA are in fact flagged by the Supreme Court and suggestions made by the Supreme Court which have been incorporated in law. Community service, friends, was in fact proposed by the Supreme Court in Sanjeev Narula's case, that is the BMW hit and run case. And in BMW hit and run case, the Supreme Court used Article 142 to direct community service as a reformative measure of punishment along with payment of compensation instead of enhancing sentence. The next aspect which I would like to touch with regard to the change of BNS is its reach. Indian Penal Code is lex loci, or it is the law of the land. Or in other words, it governs crimes or it governs acts and omissions which are offences committed in India. Only if an Indian citizen commits a crime or commits an act which is a punishable offence in India, he can be prosecuted for that crime abroad. There is an amendment where an offence has been incorporated which extends the reach of the Indian Penal Code not only to Indian citizens but also to foreigners who abet commission of an offence in India under section 48 of BNS. It says a foreigner who abets an act which, if committed in India, would be a crime, will be punished. For that, he need not abet with an Indian. He can abet with another foreigner. In other words, let's say someone in Canada abets another Canadian to purchase explosives for the purpose of blowing off or causing explosion in India. Even if the explosion is not committed, the Canadian individual can be prosecuted in India under 48 of BNS. This is a significant extraterritorial change in the law. The other extraterritorial change makes it in sync with the Information Technology Act that any computer resource in any part of the world, if is used as commission of a crime, which consequences are in India, the Indian Penal Code would stand attracted. The most significant change with regard to offence against women and child is to give chronological precedence to the batch of offences and club them together as a separate category in the BNS. It was very interesting to hear the learned Advocate General taking the cue that the comment is that the new laws are old wine in new bottles. And the best criticism has always been about this classification of offence against women and child. But there are certain very significant changes in offences against woman and child. One would feel it would be very important to see when you see section 76, which is outraging modesty. When you see section 77 of BNS of voyeurism, in these cases, the offences were considered as gender specific. Earlier, it was only a man who could outrage modesty. It was only a man who could indulge in voyeurism. Today, the word is any person. Gender of the victim is no longer relevant when it relates to procuration of child in section 96 and importation of a child from foreign country in 141 of BNS. It has all been made gender non-specific. A new offence has been incorporated in section 95 of BNS, which speaks of hiring, employing or engaging a child to commit an offence. Finally, I will come to the most discussed section, that is section 69 of the BNS. It speaks of penalizing sexual intercourse by employing deceitful means that is false promise of employment or promotion, inducement or marrying after suppressing identity, or by making promise to marry without intention to fulfill the same. I would be hesitant to make definitive comments as to the purpose of this new provision. It would be for us in the law courts to interpret them. However, I would like to make a few remarks as a student of law. What Section 69 really does is make something which is latent patent. The definition of rape, 68 of BNS, remains the same as it is in 375 of the Indian Penal Code. Consent, defined under 90 of the Indian Penal Code, remains the same as 28 of BNS. Interpreting 375, read with Section 90, number of courts, including the Supreme Court, have held that if there was dishonest promise which procured the consent of an individual for sexual intercourse, it was no consent. So it is latent in 63 read with 28, what is made patent in Section 69 of BNS. This I say again to all my honorable colleagues, that it's their call to interpret. I have just made a comment as a student of law as I see it in the perspective of the law as it exists. The other change, again, in the offences against woman and child, and I wrap up the offence against woman and child there, is incorporation of a Supreme Court directive. Independent thought redefined the age of consent from 16 to 18. Legal, again going back to the Maconian idea, judgment law creating crime creates confusion. There is uncertainty that that judgment may be changed again. So what the legislator has done is bring in independent thought, which redefines the definition from 16 to 18 as a part of 63 explanation 2 and made 18 as the age of consent. These are significant changes in addition to the repeal of adultery, which is again doing away with what the Supreme Court had already declared unconstitutional in Joseph's time, and repealing Section 377 of the Indian Penal Code, that is unnatural crime, unnatural offences, in Navdev Singh Johar versus the Union of India. However, I have some reservation about a complete repeal of 377 of the Indian Penal Code. I would have appreciated complete repeal of Section 377 of the Indian Penal Code if Section 63 of BNS would have been made gender neutral, as in POCSO Act. If you don't make 63 gender neutral, then non-consensual sexual intercourse between a man and a man does not become an offense, or at least a special offense. It is left only to general offenses like hurt or grievous hurt. This is something which the academicians, lawmakers need to consider. Then I come to the next chapter in BNS, that is offences against human body. Offences against human body, the most important thing is again another species of crime which has come into being because of collective violence. As I said, crime today is not individual oriented. It is community based, it is group based, it is faction based. Mob lynching, therefore, was an